Hello friends, I am Deepak Kumar Agarwal. I am going to discuss a case law. Case law is related to business laws. Business laws is a subject of BCom first semester of Calcutta University. So I am going to discuss the case law through a story. There was a miner whose name was Dharmodas Ghose, and the name of the case is MOHORI BIBEE versus Dharmodas Ghose. The case was decided in 1903, and the judgment was a landmark judgment. The case is 120 years back, but still relevant because no amendment still made after this case law. So the case is about Indian Contract Act 1872, and there were two parties. One is Dharmodas Ghose, the plaintiff, and the other is MOHORI BIBEE. But actually, the case was among the Brahmadatta and Dharmodas Ghose, but died. So the case was decided between MOHORI BIBEE and Dharmodas Ghose. So Brahmadatta was the moneylender, and Dharmodas Ghose approached to the moneylender and asked that he wants a loan by mortgaging his house. Then the attorney of the Brahmadatta was there, who make out the deal. So he mortgaged the property of Dharmodas Ghose and advanced him rupees 10,500. By taking the money, the mother of the Dharmodas Ghose came to know that her son has mortgaged the property. Immediately notified it to the attorney of the Brahmadatta. Now he told that that her son is a minor, and he should cancel the deal. But his mother didn't want to return the amount. So it was not much. So the Brahmadatta decided that deal cannot be cancelled. As a result, a case was filed in the lower court against Brahmadatta to cancel the deal. Lower court decided in favor of the plaintiff, and as a result, Brahmadatta filed it in the upper court, that is the Calcutta High Court. Calcutta High Court rejected the appeal, and then in the meanwhile Brahmadatta died. Then what happened? His wife MOHORI BIBEE came forward, and in place of Brahmadatta, now at that time there was no Supreme Court, but in that place there was Privy Council. Privy Council gave a landmark judgment. MOHORI BIBEE contended that under section 115 of the Evidence Act, a minor cannot change his words, that he previously thought that he was a major, but now he is telling that he is a minor, so he cannot change his statement. And she also contended that under section 64 and 65 of the Indian Contract Act, he should refund the money. But the Privy Council decided that law of estoppel under section 115 of the Indian Evidence Act, it is not applicable here because the Brahmadatta No already knew that the Dharmodas Ghose is a minor, and though he knew that, still he made the contract. So under section 115 of the Indian 115 of the Indian Evidence Act is not applicable here. But section 64 and 65 of the Indian Contract Act, what about that? But under section 64 of the Indian Contract Act, it is regarding a voidable contract. But this contract is void ab initio, that is, the contract is void from the beginning. So, section 64 is not applicable here. But section 65 is also not applicable because it should be between the competent parties. But here, parties are not competent. One party is minor. So, section 65 of the Indian Contract Act 1872 is also not applicable here. But Law Commission of India in its 13th report said that was not satisfied by this interpretation, and they gave the report, but this report is not applied, and still Indian Contract Act 1872, in which no amendment was made regarding this. Again, moneylender also contended that section 41 of the Specific Relief Act of 1877, which was at the time, but now it is Specific Relief Act 1963. So, under section 41 of the Specific Relief Act, so any decision can be made by the court as the justice may require. In regarding this, justice didn't required because moneylender already knew that the plaintiff was a minor. Again, the case can be viewed through the law of tort. So this was a fraud according to the law of tort. But if we take it as a fraud, so this will lead to the applicable of the minor's contract. A void contract cannot be made applicable through the law of tort. So this was also rejected. If we make him liable, this will also mean enforcement of an agreement. What is void? So courts have held that law will not permit such an action. So no amendment of the Indian Contract Act has been made so far, and this is a landmark judgment. That's all.